Hi, I'm Zaki Tamir from Tamir Law Group P.C. I'm a lawyer here in New York City. I'm here to demystify some very important points about DWI, a very common case that comes to my firm, and to educate people about what is considered driving while intoxicated. Now, first you have to know that there's two separate portions. There's driving while intoxicated, and then there's driving while impaired. According to the law in New York State, driving while impaired is any amount of alcohol. If you even have a small amount of beer or a small amount of wine and you're stopped by a police officer and arrested, you could be facing charges of a violation, which is not a crime, of driving while impaired. The criminal level is at 0.08% blood alcohol content. And this is roughly how that is calculated. 2 ounces of a spirit, 8 ounces of a typical wine, which is approximately 12% alcohol, or 12 ounces of beer, which is about 5 or 6% alcohol, are all equal at 0.02%. 4 drinks puts you at the criminal level at 0.08. Now, every hour you lose approximately 3/4 of a drink. That means that if I wanted to get alcohol completely out of my system, after having 4 drinks, I would have to wait 5 hours after my last drink. Another very important point to remember is that when a person gets stopped for suspicion of DWI, the police officer gives you a breathalyzer at the scene. Happens to be that this breathalyzer is very unreliable, to the extent that the courts of the state of New York do not allow it as admissible evidence in court. Even a drop of beer, and I swish it around in my mouth and I swallow it, which shouldn't appear in my blood content at all, if I take a breathalyzer at the scene, it is going to appear as if I am drunk. But when you are brought to the precinct, they're going to have another breathalyzer there. And that breathalyzer machine is admissible in court. And that checks your blood alcohol content more accurately. At that time, while you're under video surveillance, if indeed you want an attorney to be present, you should say, yes, I agree, but I want my attorney present. Do not say, I don't agree because I want my attorney present. Say, I do agree, but I want my attorney present before I blow. If you made a statement after you requested your attorney, that statement should be precluded as inadmissible evidence. If you or somebody you know was stopped by a police officer and you want to know your rights, call Tamir Law Group P.C.